It's no big secret that a federal trademark registration is the best way that you can protect and secure your business name. But just because you've made it to the finish line, you've got that trademark registration certificate in hand and it's official. Just because you've got it doesn't always mean that you're protecting what you think you're protecting. Hi everyone, I'm business and branding attorney Aiden Durham with 180 Law Co. in Colorado. Welcome back to All Up in Your Business, where today I'm going to tell you about 5 important details that you cannot overlook with your trademark registration, and why if you do overlook some of these details, that trademark you've got might actually just be a big fat waste of money. An important quick legal disclaimer before we get into it. I am a lawyer, but I am not your lawyer. This isn't legal advice, and you really shouldn't rely on free info you get from the internet. You should always consult with a lawyer for personalized legal advice. And especially when it comes to trademarks, I can assure you that working with an experienced and knowledgeable trademark lawyer is going to assure you that you're getting the protection and security out of that trademark registration that you're actually looking for. Because these 5 things that I'm about to talk about, I can almost guarantee that these come up when someone files a trademark application on their own without a lawyer or uses one of those convenient, affordable filing services online. You know, sometimes people file a trademark application on their own. They don't have a lawyer. They do their own research. They figure it out themselves, or they use an online filing service, and it works out fine. Sometimes people get exactly what they want when they file their own application or use an online service. But my friends, listen to me when I tell you, those situations are the exception, not the rule. More often than not, us trademark lawyers, we have to get in there at some point along the process or after the trademark's registered and clean up some of the messes that were made because this application wasn't submitted or reviewed or analyzed by a lawyer. So what's the first important detail that you cannot overlook, and that if you get it wrong might result in your trademark registration being a total waste of money? Surprisingly enough, the wrong owner. Having the wrong owner name or wrong registrant information on your trademark registration. This comes up often when people are just starting a business. They haven't quite gotten around to forming an LLC or an entity yet. It's on the horizon, but first we want to take care of this trademark registration so that we can make sure the name's available and secured. That's a great thing to do. But when you do that, if your LLC or your company doesn't exist yet, then on the application, the owner information or applicant or registrant information would need to be the individual, because the business doesn't exist. And so we go through this trademark registration process, and in the end, the owner of that trademark registration is the individual. But by that point, they have launched their business. They have formed their LLC. The LLC is the one that's operating the business. But guess what? The LLC doesn't own that trademark registration. You, the individual business owner, does. Now, of course, there are ways to correct this, rectify it, make sure that the company, the business, is the one that owns the trademark, because that's how it should be. The person or the company that uses the trademark should be the one that owns the trademark registration. There are ways to fix that. But if it's not done, and if there's no lawyer telling you, hey, you should fix this, I guarantee you those filing services aren't going to let you know about it. But if, let's say, you then go on to find someone who's infringing on your business's trademark, you want to send them a cease and desist, and you reference your great, amazing trademark registration, they look it up and they're like, no, your business this isn't your business's trademark. I don't know who this person's name on this trademark registration is, but it's not yours. Anyway, you got to make sure that the owner of the trademark registration is actually the owner of the trademark registration. Otherwise, it's not really going to do you any good. The second detail that you cannot overlook, and that could result in your trademark being completely useless, is putting the wrong, or making sure at least that you have a correct date of first use. The date of first use for your trademark is when you first started using the trademark in commerce. So when it was first attached to your goods or connected with your services somehow, and you put it out in the world, and the consumers, the consuming public, have the opportunity to experience your trademark out in the wild in real life. That, for the most part, is your date of first use. I cannot tell you how often I will be looking at a trademark registration or reviewing some trademark details, and I ask my client, okay, this says the date of first use was this date. That's correct? That's when you first started using the trademark? And they say, oh yeah, that's the day that I registered my LLC. Or, oh yeah, that's the day I bought the domain name. No, friends. No, that's not use of a trademark. Just registering an LLC or getting your domain name set up or having your logo designed, that is not using a trademark. And if you put a date on your trademark application that is incorrect, or even worse, if you knowingly put the wrong date, if you falsify that information, if you ever later need to go and enforce that trademark, someone might do some digging and look into it. Or if someone ever tries to challenge or cancel or oppose your trademark rights, that date of first use is going to be probably one of the biggest factors that's going to decide who owns this trademark. And if your date of first use on your registration is wrong, that could potentially invalidate your entire registration, making it completely useless. The third huge detail that you cannot overlook, and probably the one that I see most often, is applicants putting the wrong goods or services or an incomplete description of their goods and services on the application, and thus their registration reflecting the wrong goods and services. Sometimes this doesn't really arise until later on, once the trademark's already registered, and maybe someone tries to oppose it or cancel it or in some way challenge your rights. Or the USPTO is now doing this thing where they audit trademark registrations to make sure you're still using it with the goods and services that you said you're using it. And when these things come up, when someone starts checking the facts of your registration, they're going to want to see, okay, here are the goods that you listed that you're using the trademark on. Show us those goods. Show us how you're using the trademark here. And if you can't prove that you're actually using the trademark for those goods and services, you can wave goodbye to your trademark registration. I have a real life example from someone that I've worked with in the past who sold a number of different products. They made their own goods, but then they also sold goods and products of third parties online on their website. We'll just say it was clothing. It wasn't clothing, but let's say this person had like an online boutique. They made some of their own branded clothing, shirts and stuff, but they also sold clothes of other brands. This person couldn't afford to hire a lawyer for their trademark, so they went through one of these online filing services. And when you're going through that, you have to fill out a form, give the information that they're going to need to then submit your trademark application. But the people that are working on your trademark application there, the ones that are looking at it behind the scenes with this filing service, they're not asking you questions. They're not digging into your actual trademark or your use of it. They're not looking over and reviewing these facts to make sure it lines up with what we previously discussed about your business. And so this person, this client, while they're doing that form, they're asked about, okay, what goods or services are you going to use with a trademark with? And they think, okay, well, I'm selling clothes. I'm selling my shirts, my pants, my hats. So I'm going to put those clothing items on there. Good. We're good, right? What could possibly go wrong? Well, what's interesting is that clothing, in the eyes of the USPTO and trademark registrations, a trademark for clothing is not the same as a trademark for a retail clothing boutique. One is goods, the other is a service, a store selling the goods of others. What this person should have done, and what I would have recommended had they consulted with me beforehand, would say, let's register for both your clothing products and your online store, because that really is the main business, is the store itself. Sure, you're selling some of your own clothing items, but that's kind of ancillary to the actual store. So let's do both. That didn't happen. So they got this trademark registration for the clothing products. but not the actual retail store. Guess what happened? A few years later, someone else swooped in, filed and got a trademark registration for something very, very similar to it, and that then prevented that client from filing again and getting a trademark registration for the retail store services. And now, there you go. That trademark owner really, they can do some stuff, but it's going to be expensive and time consuming to now get the trademark rights that they thought they were getting in the first place. But because no one was there to tell them otherwise, that just wasn't the case. The fourth thing not to overlook, and if you're doing this, then your trademark's probably a waste of money, is if you stop using your trademark. Trademark registrations in the US can live on indefinitely as long as you continue to use the mark in commerce, and if you keep up with the required maintenance filings with the USPTO, the registration can last forever. But the important part is that you've got to keep using the trademark, because once you stop using it, it ceases to exist as a trademark. And so let's say maybe you got a trademark registration for your logo when your business first started. You wanted to make sure that logo was protected, you wouldn't have any issues with it. You got the registration, it's a great day, no problems. A few years later, you want to freshen things up. You're kind of tired of that logo, so you change it. You have someone design a new one. Well, guess what? That is now a new trademark. And that existing trademark registration that you have for your first logo doesn't do anything for your new logo. It's now just sitting there collecting dust. And if you're no longer using that first logo, then that trademark registration is useless. And finally, the fifth thing that you can't overlook, and if you're doing this, then your trademark registration is probably a big fat waste of money, is if you're not actually enforcing your trademark rights. A trademark registration is only going to do you so much good on its own. But once you've got the registration, it's now your job to protect this valuable trademark registration that you've got. The trademark certificate's not going to go around and see if there's infringers out there using your trademark or something similar to it. The USPTO isn't doing that for you. They're kind of doing that with respect to new trademark applications that come in, but they're not monitoring trademark usage for you. That's your job. And if you see that people are using your trademark or using something confusingly similar to it, something that might kind of start to dilute or override the goodwill or the brand recognition that you've built, if those things exist and you do nothing about it, you are essentially, your trademark's dying. It's not living up to its full potential because it needs you to enforce the trademark rights that you have. And so this comes into play with monitoring the USPTO database for new applications that are filed that might be conflicting or confusingly similar with yours, monitoring the internet, seeing who else is out there that might be using a trademark like yours, and then proactively taking steps to prevent that from happening. So sending out cease and desist letters or social media takedown notices or infringement lawsuits, whatever you've got to do to protect your trademark, you've got to do that. Otherwise, it's going to die. It's not really going to die, but it will eventually. You're whittling away at your trademark rights if you don't enforce them. And what good is a trademark if the rights are just gonna be gone? So if you're not willing to actually take the steps to enforce your trademark rights and monitor third-party usage, then your trademark's a waste of money because it's not going to do that for you. So I hope it's obvious at this point that the best way to avoid these issues from happening and to avoid your trademark from being a waste of money, being useless for you, is to work with an experienced and knowledgeable trademark lawyer who can counsel you on the process, let you know, here's the best way that we can structure this application to give you the best protection possible. And they'll say, hey, we shouldn't do this, or hey, we should do that. And most of us, once your trademark's registered, we're going to remind you, hey, don't forget to monitor that. We offer those services as well. Don't forget to file your maintenance documents. You want someone there who's on your side, looking out for you and your trademark registration and your rights. And I assure you, these online filing services that shall not be named, they're not doing that for you. If you learned a thing or two in this episode, go ahead and like this video, give me a little thumbs up, and be sure to subscribe if you haven't already done so. If you want to learn more about trademark registration and how trademarks work, then check out Brandish, my DIY trademark guide that you can download for free. And I know we talked a lot about date of first use in this episode. I've got another video where I dive deeper into what the date of first use is and how you don't get it wrong. So click here and I'll meet you over there. Thank you so much for watching. I'm Aiden Durham and I'll see you next time.